So I've got here our proposal or our plan slideshow, and let's just jump right on into it. So to start with, we aren't going to be talking about President Trump's big, beautiful budget bill. It does have about $4.5 trillion of tax cuts. However, he's proposed around $8 trillion of tax cuts. And so I'm not sure which ones are actually going to be showing up. So instead, what we're going to do is look at all the other tax issues that we do have more clarity on and jump into those. First of all, many of these are going to be around the proposal for the estate taxes and the end of our estate tax, the current exemption, which is scheduled to be cut in half. So we'll be looking at the estate taxes. And so some basics on the estate tax is what tax rates are there. And let's see, I'm going to switch over here. I cannot get the screen to show the presentation, so we're going to have to restart that. And Taylor will take that over for us. So basically, with the estate taxes, then we have the gift tax with the Washington estate tax with a $2.193 million exemption, the federal estate tax with a $13.99 million exemption. We have gift tax exemptions and the transfer taxes. Who's going to be impacted by this? Anyone in Washington states who has estate taxes exemptions, anyone who might or is above the Washington exemption, anyone who might be above the federal estate tax exemption, business owners, real estate investors, families with substantial generational wealth will be interested in today's presentation. And just kind of jumping into our updates here. So the first part we're going to see here is what exemptions are currently and what those exemptions might be changing to or could be changing to here in the future. To start with, we have the federal estate tax exemption, which I mentioned, is currently $13.99 million, and it was $13.61 million last year. So that is an increase for 2025. We would anticipate it going up in 2026 also due to inflation adjustment, as long as we get an extension of the prior Trump tax cuts. Also, we have the current annual gift tax exemption and the Washington state estate tax exemption. You can see that the Washington state estate tax exemption has not gone up. Really, it hasn't gone up for the last 5 or 6 years because the inflation adjustment has been broken. But we are actually having two provisions in the Washington state legislature currently, which would look to restore that indexing and potentially raise the exemption also. So we will look a little bit at that here as we go. Finally, we have the Washington state capital gains tax. The current exemption is $270,000 for 2024. That's an increase from the $262 from 2023. And we would expect another increase in 2025 on that one also, but that hasn't been published yet. So kind of looking at that Washington state estate tax exemption and how that works. If you aren't familiar with how that works, we have the current exemption of $2.193 million, and the taxes are at taxes between 10 and 20%, depending on the size of the estate. Now that exemption has been, again, like I said, not increasing for the last 5 or 6 years here, and this was really due to the way that the legislature had set the exemption to increase with the cost of inflation indexing, and that stopped being published. And so the Department of Revenue took the position that without the publication of the number, then it couldn't go back up. I believe that it was mostly a change from, say, Seattle Tacoma Index to Puget Sound Index. They changed the name of it, but that was not that caused us a problem there. Just looking at these exemptions over time, you can see that they have gone up at both the federal level and the state level. Well, we can't see the changes there on the state side, but the federal estate and gift tax exemptions have gone up. You can see in 2018 the impact of President Trump's prior estate tax exemption increase, where it essentially doubled. And if that law were to sunset due to the Byrd rule, then we would see it go back to the current, or essentially about half that value. The federal tax rates are at 40%. Just on that, you can see that. Looking at the proposed legislation for the state of Washington. Now, this is kind of interesting. So we have seen in the past a few bills get into the state legislature dealing with the Washington state estate tax, and they haven't made much progress in the past. So we have two bills that are kind of flowing through there right now. The first one is this House Bill 2019, which would increase that exemption up to around $3 million. And then it would basically restoring the indexing that we would have seen if it hadn't been stalled in 2018. And then it would also go ahead and start that indexing again. So we would see those numbers go up along those lines. That would be very helpful for many Washingtonians, because the exemption would increase and would take them outside of having to be subject to the Washington estate tax. Unfortunately, that bill also increases the top Fed or Washington estate tax rate up to 38%, which is really close to the size of the federal highest rate, 40%. And it is more than, or nearly double the size of this federal capital gains tax, and would make planning for larger Washington states a top priority if that bill went in. House Bill 1375 is a more modest fix. It looks to restore the indexing, but it does not increase the exemption for us. So it leaves us at the 2.193, but it would restore indexing going into the future. So that would give us some relief going forward. And that one would not include additional tax rate increases. So that would be an easier bill from that perspective. Now, when we look at these two bills, they're both sitting in the Finance Committee. They had hearings and read into the Finance Committee there at in the end of February. The one thing about House Bill 2019 that kind of leads us to think that might not go forward is Governor Ferguson has stated that he does not wish to increase taxes. And so with that no increased tax claim position, then he would supposedly be against having that kind of a tax bill. On the other hand, we are seeing significant budget shortfalls, and so some taxes may be needing to be funded. And if a bill increasing the estate tax rates were to end up on Governor Ferguson's desk, there's a high likelihood that he would end up signing that if the bill met his other higher priorities. The House Bill 1375 then would be an easier one to pass. It would have some impact on future tax receipts as that indexing was restored, but would seem to have more support currently. One thing to consider, though, is that neither of these bills is addressing the Washington state lack of portability. So at the federal estate tax level, we have portability, which allows the if you don't use your exemption, for it to be handed to your spouse. And at the state level, we don't have that as one of our features. And so without that feature, we do need to continue to do our marital planning that would include a testamentary trust at the first death. Those are often called exemption trusts or credit shelter trusts or Washington exemption trust. So that type of planning will be needed going into the future under either of these bills. And because of those exemptions not still being significantly lower than the federal level, we would still want to look at gifting as an alternative to paying the Washington estate tax. So the idea there is we do not have a gift tax here in Washington. So as long as you have ability to make gifts at the federal level, you can use that ability to protect and shield more of your estate from Washington estate tax. All right. Moving on then to the federal estate tax law changes. I mentioned a little bit about this as we've been talking, and it's really looking at that Tax Cuts and Jobs Act that President Trump signed the last time he was on office. And that increased those exemptions and with the indexing has brought it all the way up to 13.99 million. And it also has that 40% estate tax rates. And that is scheduled to be sunset as of 2026. And that would be a huge change for larger estates. We would see then, the need to do additional tax planning for estates greater than 7 million, and also for married couples with greater than about 14 million. They would need to be doing more estate tax planning to try to address that decrease in that exemption. If we look at, because of that uncertainty, because we don't know for sure, what the new tax law will be. And again, this is there's a lot of speculation that we will see some kind of act come out of this Congress, a tax act, which would provide some relief for this change. But we haven't seen that bill yet. My hope was by the time we had this meeting today, we would have seen that already or seen some indication of what that bill will be. We do have the bill that passed the House, which hasn't been taken up in the Senate yet, and we will likely see reconciliation on that bill. But again, there's about $8 trillion of tax cuts that have been proposed, and even in the bill that came out of the House, there was only 4.5 trillion that was earmarked for tax cuts. So something's going to have to give in reconciliation, and also, of course, addressing the fiscal needs that the government will have going forward. So we'll see what that is, and I hope to have more to say about that as we get later into the year here. But that is kind of an unknown at this time. Because of that unknown, we don't know exactly what to do. But if we do not see, we could see an act this year. We'd hope to see that this year. But I do remember back in 2010 when we had a similar issue, and we did not actually see the bill pass until the following year, and then they made it retroactive. So it's possible that we might not even see the future federal estate tax law for 2026 until after the end of this year. So what does that mean we should do as planners, as taxpayers? How should we approach that that federal estate tax issue there? So I've detailed a couple of approaches here. A conservative approach would be to lock in your exemption now. You have it now. Don't wait for a rush and trying to get all of the exemptions or do all the planning at the end of the year, but go ahead and get your documents aligned and your assets aligned, and make those gifts now to use up that federal exemption and lock that in before the exemption goes away. On the other hand, that might be a bit too you might want to take a more moderate approach because there is likely going to be needed either trusts or limited liability companies or other gifting tools. It's best to get those aligned up, those documents drafted, the tax numbers, get those from the IRS that you're going to need, get your trustees aligned, get your bank accounts set up so that if you do want to make those gifts before the end of the year, you're already ready to go and you don't have to rush and trying to get a bunch of documents or get everything organized or having to work with the banks or the financial institutions to make those gifts happen. And so that would be a more moderate approach, still allows a lot of flexibility for the gifting. The gifting here is also going to, do double duty. It not only helps with the federal 40% tax, but it also helps to address that potential Washington state estate tax. So gifting all around is a good idea for Washington estates. An aggressive approach would be to just assume that that exemption is going to pass. Go ahead and hold off on any major gifts. Don't do any additional planning, and then confirm that once we know what the estate tax law is, then go ahead and make your decision based on that. I would urge you to consider how much liquidity is going to be needed in your estate to pay those estate taxes, and make sure that you have a way for those to be paid if something were to happen prior to being able to do any additional planning, or if you lost the opportunity to do that additional planning and where then your estate was stuck with that federal estate tax hit. So that's kind of the approach there on the federal estate tax provisions. Again, I think that there's a probably strong possibility that we will get at least an extension from President Trump, but there are a lot of tax and other priorities that are floating around in the new administration, and so it's hard to know exactly what will come from that. So that's what we have there. I do have one final update for you, and that's going to be on the FinCEN Beneficial Ownership Reporting Corporate Transparency Act. If you've been following any of the drama that's been going on with this has been happening now for us for quite a while. And this really applies to all small businesses, LLCs, corporations, and the like that are set up here in the U.S. and have where it's a new reporting requirement to the Department of Treasury, and this has come under quite a bit of fire. It would cover millions of entities, and it's come under quite a bit of fire because we've had court cases that have gone made their way up to the appellate level, and in a number of different jurisdictions. And there's been, trying to figure out, hey, do you really need to do this? And then there's been extensions that have happened along the way. It's relevant because the fines are impressive. I mean, there's quite a bit of fine for not complying. There's also a fairly significant compliance requirement on everybody. Just the paperwork to get it done, getting the filing of that done, and setting up those entities to work properly. So our latest is that we have that's been extended on the deadline for filing past the end of the year, and it went into now March 21st is the time that we have there. But interestingly, on March 3rd, the Treasury Department announced that they would no longer be enforcing any penalties on U.S. citizens or U.S.-based companies regarding this change there. And so without the penalties there, you don't have to file right now. There is still that deadline, but there will not be any enforcement against a U.S. citizen or U.S. companies. So definitely, if you are a non-U.S. citizen or representing or involved in a foreign reporting company, I believe you still have that need to file there, and otherwise you'll be facing those penalties. In the future, though, the Treasury has also indicated they're looking to actually change these rulings. So they're going to change the law or the way that it's applied so that it would only apply to those those foreign reporting companies and not the U.S. companies. The burden on the small businesses would seem to be too great for that to be something that they wanted to have happen there. So this isn't exactly a tax issue, but I think it is kind of an interesting one. It's been one we've been following now for a number of years here in our office. We do represent a number of small businesses and LLCs that are used for tax planning and estate planning. So it is related in that way. So anyway, that is our presentation on the estate tax law changes and other tax changes that we know about. And I would love to answer any questions that anybody have here. So let's see here quickly. Where is my? All right. Let's see here. All right, we do have a question about what are some common estate planning strategies to reduce the estate tax liability before the 2026 sunset? Let's see here. I can go ahead and close out of that and I'll let you guys see my face. I get out of that. Oh, and actually, Taylor, maybe you can give it back to me, the screen. Yeah, so I think the easiest thing is you can actually gift just by writing a check. You could gift by transferring money into a beneficiary's account. You could make a gift by giving real estate, by assigning a deed. There's a lot of ways that you can do those gifts. From a plan giving perspective, what we really are looking at is, can we do those kind of gifts and still maintain the control or the security or the access to those assets in a manner that you need as the owner of those assets. And it might also be that your potential beneficiaries are underage, or maybe there's some asset protection issues if you were to make gifts directly to them, or some money management issues. So these types of issues are the things that we're looking at with the different types of entities that we might use for gifting. A limited liability company, for example, we sometimes think of that like it could almost work like a family bank where you can maintain the management of the company but move some of the equity, the ownership, off to the next generation. Irrevocable trusts can be used. They're great tools. Instead of using a business structure, you're using a trust structure, which would have a fiduciary who's looking out for the best interests of the beneficiary. Now, those can be drafted in very tax efficient ways, so we can decide where best to have the income taxes on those trusts, and that can be very useful in many ways. So we can do that quite a bit. So one example that we've had that I mentioned in the slides was that of a SLAT, and that's a spousal lifetime access trust. And that type of trust is used when we have a married couple and we would like to make a gift, but we want to make sure that as a couple, they're still maintaining management, control, and access to those assets. And so the spouse is actually the beneficiary, and you're making a gift from one spouse to the trust for the other spouse, and that would be an example of the type of trust we might do. You could also have a trust for a minor grandchild, and so this can be a great technique because you're not only making the gift out of your estate, but you're also not increasing the size of the estate of your children, who may also have estate tax issues. And so we'd move on now to the grandchildren's level. Since they're underage, then that would be a good way to to make sure that it's being managed and asset protected the way you'd like. let's see here. Right, so one of the questions was about, again, back to the Washington State exemption, going into that a little bit more. Yeah, so the Washington State Bar Association has an estate planning and section that I'm a member of, and one of the things that our section did was send down support of these bills to the state legislature, and we pointed out that the intent of the initial act was that there would be indexing for the Washington State estate tax, and it was really this technical change where a publisher that was outside of the control of the state legislature had changed the way that they were publishing the inflation adjustment. And because of that change, it meant that the Department of Revenue was no longer tracking along the indexing. And the Department of Revenue did not feel that they had the legislative authority to, on their own, change that indexing from what had previously been published to a more current published indexing. And so that's where that ended up kind of coming apart technically. We unfortunately, if that had been in place, you can kind of remember back to where your estate was in 2018 and say, yeah, I've seen quite a bit of a growth in my estate since 2018. And maybe if in 2018 your estate would have been under that exemption, you still may have been under that exemption today. And so there's a lot of folks who are essentially getting an estate tax increase every year because that exemption has not been indexing. Now, I've seen estimates that have said that, if we had been indexing since 2018, we'd probably be around 2.9, 2.95 million or so would be where our current exemption should be. So, which would mean a married couple could protect nearly $6 million here in Washington instead of closer to 4.4 million, which is where we're currently at. So I do hope that the state will get around to fixing that indexing. However, I really would rather them not, so dramatically increase the tax rates up to 38%, which was that proposal of the first bill that we were thinking of there. That would kind of get rid of one problem but cause another problem. So let's see here. Let's see, do we have any more questions? Let's see. Portability. Let's talk about that one a little bit. So we do have a question on portability. Yeah, so the federal, I often will tell people this in my meetings. I usually describe it as a coupon. So if you think about the state of Washington exemption as a coupon worth $2.193 million, this is my symbol for a coupon. Down in the corner, it says non-transferable. So that means if you were to give your assets in a way that would not be subject to estate tax, like for example, by making a gift to your spouse, then you're not actually using your coupon and you're losing it. And let's say a married couple had $4 million at the first death. Their plan was to give everything to the survivor, which makes sense. But now the survivor has a $4 million estate and they only have the one coupon. And so they're only able to protect the $2.193 million from estate. And that's the problem. We don't have the portability there. So we have a problem where we're only getting the use of one coupon. At the federal level, it's done differently. This was a change at the federal level that came in actually during President Obama's term. So it was after we'd already set the Washington state tax, and we haven't gone back and updated that and added this portability feature in. But the way the portability works at the federal level is, of course, first of all, it's a much larger coupon, and it still says non-transferable down in the corner, but now it says except to spouse. So if you don't use your coupon, you can essentially give your coupon to your spouse, and it allows a married couple with up to $28 million at the federal level to go ahead and eliminate federal estate taxes because of that. So it'd be a nice feature to have that here in the state of Washington. Because we don't have it, we're essentially using the planning, some of the planning techniques that we used prior to that Obama era change, which meant that we had to allocate the exemption to a trust for the surviving spouse. Instead of making the gift directly to the spouse, you'd give it to a trust for the spouse, allocate your exemption there, and then that's the way to protect it. Now, the good news is once you do that at the first death and you allocate your exemption, any growth that happens on those assets from then on will be excluded from the surviving spouse's estate. So in my earlier example of the $4 million estate, say the $2 million went into that trust for the benefit of the surviving spouse, but perhaps the death happened when we weren't expecting, maybe someone in their 60s, for example, and the surviving spouse survives into their 80s. There'd be 20 years of growth that could happen on that account or those assets that are in that trust. So you might see it go from 2 to 4 to $8 million in that amount of time, and 100% of that would be exempt from the Washington estate tax. So that is a benefit of doing that kind of planning that exists even without portability, because you do see that all of the growth happen in those assets outside of that. Let's see. Do we have any other questions? Let's see here. I don't see any more at the moment. I do apologize for getting started a little slower this morning or this afternoon. I don't know what happened with that. I was having a computer glitch, of course. All right, folks. I don't see any other messages here or questions. If you do have any more, go ahead and send them into the team. We'll try to answer them. We will watch to see what happens with President Trump's new proposal and how that works through Congress and the House and the Senate. And when we get more indication of what we're going to finally see at the federal level, including income tax changes and the estate tax changes, I will come back on and give you another little presentation. But thank you again for everyone for joining us today.